Justice Clarence Thomas, after his bruising confirmation hearing in 1991, is said to have told his law clerks that the liberals made my life miserable for 43 years, and I'm going to make their lives miserable for 43 years. That vengeance has seemingly fueled his complete disregard for any sense of propriety and ethics. This morning, the nonprofit investigative website ProPublica posted yet another detailed investigation into Thomas, and what they uncovered is shocking but no longer surprising. In his 30-plus years on the court, Thomas has amassed new billionaire buddies like Harlan Crow, whose relationship with Thomas was the subject of previous reporting. Now we're learning about others, like Wayne Huizenga, who started Blockbuster Video and owned the Miami Dolphins, David Sokol, a wealthy financier who introduced Thomas to the Horatio Alger Society, and Tony Novelli, an oil baron. They all reportedly lavished their Supreme Court buddy with hundreds of thousands of dollars worth of gifts, private jet lifts, and vacations. According to ProPublica, which cited flight data, security detail records, tax court filings, interviews with more than 100 eyewitnesses, and a host of other sources of information, Thomas received at least 38 destination vacations, including a previously unreported voyage on a yacht around the Bahamas, 26 private jet flights, plus an additional 8 by helicopter, a dozen VIP passes to professional and college sporting events, et cetera, et cetera, et cetera. And by the way, he was typically perched in the skybox for those. 2 stays at luxury resorts in Florida and Jamaica, and 1 standing invitation to an uber-exclusive golf club overlooking the Atlantic coast. None of these gifts or the names of these newly reported boosters appeared in financial disclosures. While Justice Thomas does not appear to have violated any laws by failing to report his stays at his friends' homes, experts say it sure looks like he may have violated the law by failing to disclose the flights, the cruises, the VIP sports tickets, and other perks he got only after he was seated on the Supreme Court. NBC News reached out to Thomas for comment, but didn't immediately hear back. It is important to note that ProPublica was unable to identify if these billionaire benefactors had any legal cases before the Supreme Court during their documented relationships with Thomas. David Sokol told ProPublica, "We have never once discussed any pending court matter." Novelli did not respond, and Huizenga died in 2018. When ProPublica reported in April that Thomas was receiving luxurious trips and financial assistance from Harlan Crow, Justice Thomas said he was advised that this sort of personal hospitality from close personal friends who did not have business before the court was not reportable. Thomas has also complained in the past that serving on the highest court in the land wasn't worth it for the pay, but rather for the principle. I guess the access, power, and prestige make it even better, since it helped him meet his cadre of billionaire friends, who all seemingly love to lavish him with really expensive gifts while he sits on a court that continues to deliver major victories that just so happen to appeal to their ideological beliefs. Just ask yourself, dear viewer, if Clarence Thomas didn't rule the way he did, do you really think that he'll be invited on these trips to the clubs, to the yachts? Joining me now is Don Fox, former acting director and general counsel of the U.S. Office of Government Ethics. He was quoted in the ProPublica piece. Thank you so much for being here, Mr. Fox. And that is my challenge with the Thomas defense and those who defend him. Number one, and I think you might have said this in the piece, were these people his friends before 1992 when he got on the court? No. Number two, if he didn't rule the way he did, would they still take him on the yacht and take him on the chopper? I would argue no. And so to me, the bribe isn't, hey, Clarence, can you please rule this way on this case? The bribe is, you doing this is how I get you the gift. You doing this is how you get the lifestyle. And you not doing it would probably take the lifestyle away. What do you think of my kind of syllogism there?
Well, I think, Joy, that the defense that there were no cases before Justice Thomas in which these gentlemen were parties, or the fact that there wasn't a bribe involved, is an awfully low bar in terms of public service. I mean, the whole point of public financial disclosure in the first place is public confidence in senior officials, whether they're career officials, as I was for a long time in the government, or people who enjoy lifetime tenure like Justice Thomas. If he had done the right thing, first of all, by declining all this lavish entertainment and these trips from his newly found friends, or at a minimum, if he had at least disclosed it, you and I wouldn't be having this conversation.
And the thing is, like, even the attempts to sort of mitigate the kind of appearance that he's living high on the hog, that famous RV trip that he took where they did a documentary to try to make him look good. It turned out even that, his $287,000 RV, luxury RV, came as a result of a real sneaky sounding loan from another rich friend. And so even the appearance to make him look like an everyman comes across as shady. And so, at this point, I think what a lot of people wonder is why isn't there anything that can be done in terms of what seems to be ethical violations?
Well, I think in terms of that question, why can't something be done? And I think that's because the court itself has failed to adopt any of the standards that, in fact, are imposed on the lower courts. And that's a reluctance that I think many of us who have been in the ethics profession simply don't understand. So I think that's kind of the first answer. Is there possible? I'm sorry.
Go ahead.
I was just going to say, is there any possible recourse? I think the only possible recourse, and I don't really see it happening in this case, would be if there were some possible prosecution for knowingly filing a false public financial disclosure statement. Those kinds of prosecutions have occurred for much lower level officials. But we're really in an uncharted territory here when we're talking about an associate justice of the Supreme Court.
I can't imagine this Justice Department with all of the Trump stuff on its hands saying they want to go into a Clarence Thomas file. I just can't imagine it happening. This was the chairman of the Senate Judiciary Committee on these newest revelations. This is Dick Durbin, Senator Dick Durbin. Justice Thomas and Alito have made it clear that they are oblivious to the embarrassment they have visited on the highest court in the land. Now it's up to Chief Justice Roberts and other justices to act on ethics reform to save their own reputations and the integrity of the court. And if the court will not act, then Congress must continue to do so. Justice Elena Kagan has said, no, Congress can regulate us. They confirm us and, they fund us and they can. Short of regulation, it seems to me that you're not going to embarrass them into retiring, because if they retire, they don't get the gifts anymore. So the incentive is to dig in and keep doing it because you get to keep going on the trips.
Well, I think in that respect, you could be right. But Justice Kagan is also certainly right that Congress has the constitutional authority to pass laws that limit restrict the ethical conduct of the justices. I mean, indeed, the very law that we're talking about that requires public financial disclosure was enacted in 1978 by the Congress. So it's also public financial disclosure should not be new to Justice Thomas. He had to file these forms when he was chair of the EEOC, which he was for many years.
Yeah, he just pretends he doesn't know because he likes the trips. I think that's very clear. Don Fox, thank you so much for being here.